Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. We are often asked, I have a divorce settlement, how do I contest it? Well, it's an interesting thing because when people say, I have a divorce settlement, what do they really mean? Do they mean that there's a proposal that they don't like to settle the case, but they object to the custody, parenting time, support, child support numbers, property settlement issues, debt allocation? Do they object to that? If they do, and they feel powerless to navigate that system, they have to retain an experienced attorney who can help them know what they're supposed to bargain for, know what's fair, know what the court will likely approve in the event that it falls apart, and it's got to go before the court. What will the court likely say? And that will really help a lot. Now, if the question is, I've already agreed to a divorce settlement, we've already put it on the record, and now I'm having second thoughts, well, good luck on that proposition, because there are certain things that the court will always take a second look at, even if the parties have agreed. Like, for example, things that have to do with the child. The court may approve of the custody arrangement, but the court can take a look at that even after the settlement if it feels there's a change in circumstances, there's a compelling reason to do so. If mom has the custody, dad was okay with that, but all of a sudden mom's become a drug addict and alcoholic, you bet the court is going to revisit the issue of custody and consider maybe making a change. But if you're talking about revisiting the issues of property settlement, where the parties have already agreed, you're going to get the house, you're going to get the money, you're going to get the car, whatever it is, and you're talking about going back and reinventing that after the court has approved it, after it's been put on the record, signed and sealed, it's very, very unlikely that the court will go back and allow a contesting of that property settlement. You can argue that there was fraud, that there was a non-disclosure of assets, that there was a lack of transparency, and in that circumstance, the court might consider it. But be aware that absent that kind of fraud, the courts are generally very much unwilling to redo a property settlement because otherwise it never ends. The court has a very, very strong sense that things need to come to conclusion. There needs to be finality. The court cannot foster an environment where people fight forever. And the court can't have it said of itself that it approved the property settlement, but you file a motion to set it aside. Okay, we'll set it aside. In the absence of a compelling reason, like some ineffective assistance of counsel, some kind of fraud, some sort of non-disclosure, in the absence of that, the courts are genuinely going to be unwilling to revisit a property settlement issue. Now, some cases fall squarely on one side, some on another. If you have any questions about your case, of course, reach out and we'll be glad to help you out.